Someone recently left a comment on my channel that was a video request. Basically, he was served with a temporary restraining order. He's being accused of abuse by his ex, but he has no criminal history. There's no strong evidence. A few other things, which I'll get into in a minute. But this is a situation that I think a lot of people who were served with a restraining order find themselves in, and he asked me to make a video where I address his specific situation, so here it is. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything that you need to know to win your restraining order hearing. So let's jump right in. All right, now let's look at his comment first. He says, can you make a video of how a TRO ends up if there's no assault, no strong evidence, the respondent has a clean record, and he's 27 years old? And the petitioner is using abusive process by putting the respondent is going to kill her and her family with no evidence. And yes, I'm the respondent. It's crazy. My ex added allegations from 8 months ago and didn't add a timeline in her statement, just put allegations. So let me give my take on the situation. From your comment, it seems very clear that you don't really know what the evidence will be, because what she wrote down in her declaration to get the TRO isn't very much. At the hearing, it's important to remember she can say things that aren't in her declaration. What you would want to do, and be careful with this if you don't know how to do it, maybe you can find videos out there on how to do it. I teach you in the course. Also, is basically question her and point out, hey, you put everything that was important in your declaration, but you didn't mention any of this new stuff that you said here today. Like in her declaration, she says you threatened to kill her and her family. But then she adds in court that you also punched her and knocked her out. Well, if that wasn't in her declaration, that you punched her and knocked her out, then you really have to wonder why not. But one thing that you do know for sure is that you didn't do this. There is not going to be a text message from you that shows up that says that you are threatening to kill her and her family, right? There's not going to be a video recording of you on a Ring camera. There's not going to be a voicemail of you threatening. Does anybody leave voicemails? But there's not going to be any of those, voice memo where you threaten to kill her and her family. That just, it simply doesn't exist. So if in the absence of hard evidence, it's not that there is no evidence. Her testimony is evidence, so is yours. But it's all about credibility. Calmly explain your side. So you would say, I've never assaulted Miss whatever in any way. I've never threatened to kill Miss blank or her family. Bring with you at least 3 copies of any text messages that were around the time that she says that you threatened to kill her. Like, let's say that she says it was about 8 months ago you threatened to kill her and her family, but then 7 months ago she's texting you wanting to meet up for coffee or a drink or something. Bring those text messages in, because it's not absolute hard proof, but it's circumstantial evidence that what she's saying is not true. You also want to tell the judge, I have no criminal history. If the petitioner has a motive to lie, say, look, I didn't do any of these things, Your Honor. I don't know exactly why the petitioner brought this up. I do know that she was very upset because I broke up with her, or she was very upset because admittedly, I cheated on her. I wasn't the best boyfriend, but I certainly didn't abuse her. Breaking up with somebody, cheating on somebody, that's not the same as abuse. And if those are the reasons why, and I'm not saying for this particular commenter that those are, but if there's some motive like that you can bring up that is a reason for the petitioner to be really upset with you, then bring it up. And sometimes it's not always that clear. There are some people that do it just for attention, or maybe they make it up at first and they're hoping that it will bring you back, and it doesn't, and then they become angry because of it. It's a more convoluted sort of motive, so you may not really have anything there, but if you do have a clear motive, then make sure that you bring that up. Do not attempt to go on the offensive. A red flag to me in this comment is where it says the petitioner is using abuse of process. Don't talk about abusive process. That is not what the hearing is about. If it's a domestic violence restraining order hearing in California, the hearing is about whether or not it is necessary to issue a domestic violence restraining order to prevent the occurrence of future domestic violence. It's not about abusive process. None of that matters. It's not about perjury. It's not about whether the petitioner should have some action taken against them. You are simply defending as the respondent. So, since the issue is whether a domestic violence restraining order is needed to prevent the occurrence of future domestic violence. If your ex is saying that the last time that they heard from you was 8 months ago, then point that out to the judge and tell the judge, Your Honor, this was not a good relationship. It was not abusive. I did not abuse the petitioner, but I've moved on. I haven't contacted the petitioner for 8 months. I have no intention of contacting the petitioner in the future. That's important because that shows the judge, if the judge believes you, that it's not necessary to issue a domestic violence restraining order to prevent future domestic violence. You don't even want to talk to the petitioner anymore, right? And make sure that you say that in a very calm, respectful way. You are the epitome of reason. You are so calm. You are not angry. You're not annoyed to be here in court. You're not annoyed to have all these lies brought against you. You are totally calm. You are rising above it, and you are simply talking to the judge and explaining to the judge your side of things. Okay, so what else can you do? There's only so much you can control in this situation. But one thing that you can control is how you present yourself. So I don't require all my clients to go out and necessarily buy a whole new outfit. But since you're asking for my advice, and since maybe you don't end up hiring an attorney, I'm just going to tell you, if I were in your situation as a guy, what I would for sure wear is a light blue, light lavender, or light pink shirt, depending on which one you like and what looks good on you. I would say light gray slacks, light colors. And by the way, when I'm talking about the shirt, I'm talking about a button-down long sleeve shirt. You don't have to wear a tie, you don't have to wear a suit, but you should wear a nice button-down shirt that fits you nicely. Wear light gray or dark gray if you must. Nice dress pants that are hemmed nicely with nice dress shoes as well. A belt, which by the way, you're going to have to take off at security. So when you're standing in the line, once you get in the building, make sure you just start taking it off. What you wouldn't want to wear is a red button-down shirt, for example, and black slacks. Those are angry colors. Red makes bulls run towards it in anger. You don't want to do that. You want to be the picture of serenity and professionalism. If you have any documents, make sure you have 3 copies of every document. This is very simple, and I know I talk about it in a bunch of videos, but make sure you have at least 3 copies of every document. Have them in separate file folders if you can. Just make everything as neat as possible so that you are the definition of professionalism. Make sure you don't have your phone out in the courtroom. Be nice to everybody in the courtroom and the courthouse, even if they're rude to you. Many times the clerks are rude, the deputies are rude. Who cares? It doesn't matter. They have to keep order in the court, and sometimes they have a bad day. Don't worry about that, but be nice to them, because you know who the judge has lunch with sometimes? You know who the judge chats with on breaks and has coffee with and has donuts with on Fridays? The clerks and the deputies. So be nice to them, because if you're a jerk, the judge will for sure hear it, and that could cause you to lose your whole hearing, no matter how nicely you're dressed, no matter how well you present your evidence, and no matter how bad the other side does. I hope that this helped, and look, you can keep browsing YouTube, you can keep, whether you are the person who commented this, and thank you so much for watching, by the way, and for leaving me that comment, you can keep looking for the answers or just get them served up to you on a silver platter. So I highly do recommend taking a course. Even if you just take the first free class with me, at least you'll have more information. You'll have kind of an outline of what you need to learn, which can be very helpful, because when you're trying to figure out something new, you don't know what's important. You don't know what you don't know, right? So, I mean, that's why courses are so helpful. Anyway, if you did find this helpful, please don't forget to like, subscribe, and ring the bell.